Hello, everyone. My name is András Kupecz. I'm a legally qualified judge at the Central Division of the Unified Patent Court, Section Munich, and you are listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 148 of IP Fridays. Today's interview guest is András Kupecz. He is a UPC judge, and of all judges at the Unified Patent Court, the UPC, he has worked on probably the most UPC cases. Why this is the case and what he learned, we are discussing in today's interview. But before we jump into the interview, I have news for you. Nokia and Oppo and a global patent battle. Nokia and Oppo have signed a cross-license agreement. They have ended what was probably the biggest patent dispute over the last 3 years. In its press release, Nokia states that Oppo will make royalty payments along with catch-up payments to cover the periods of non-payment. EU lawmakers have voted to establish a body for setting royalty rates in standard essential patents at the EU IPO. This project has drawn sharp criticism not only from large patent holders such as Nokia, Ericsson and Siemens, but also from the European Patent Office and the standard setting body ETSI. Also on this podcast, former USPTO director David Kapos criticized this project for solving a non-problem. First of all, so far the EU IPO has absolutely no competence in patent matters. Secondly, there are only a very few cases per year that go to court for royalty rates in standard essential patents, and the courts work really nicely. Let us see if the EU IPO will establish this body against the strong recommendation of basically all stakeholders in this game. Now, let's jump into the interview with András Kupecz. Today's interview guest is András Kupecz. If you don't know who András Kupecz is, he is a legally qualified judge at the Unified Patent Court and holds an LLM in private law from Amsterdam University and a Master of Science from Utrecht University with focus on molecular biology. He also was an active European patent litigator and was duly qualified as a lawyer and a European patent attorney before taking up his duties at the Unified Patent Court. He is based in the Central Division of the Unified Patent Court in Munich and also serves on local divisions, such as the Munich Local Division. Thank you very much for being here.
Pleasure. Thank you very much for having me.
All right. So just in the very beginning, I say that the following thoughts and statements are your personal opinion and not the official opinion of the Unified Patent Court, of course.
Clear.
You are one of the busiest judges at the Unified Patent Court. Can you tell us a little bit about your first half year at the Unified Patent Court?
Well, thanks for the question. And indeed, the first half year has been quite an exciting one. First of all, in the Central Division, I have been the judge rapporteur on our first cases. And the role of judge rapporteur in the Unified Patent Court is quite a time-intensive one, especially in the written and interim phases of UPC proceeding, which lead up to the oral phase, where the presiding judge takes over. And as a judge rapporteur, I, for instance, had to decide on preliminary objections in relation to competence and jurisdiction, requests for extension of time limits, security for legal costs, confidentiality of documents, and so-called to a Rule 2621B requests for public access to the file. All of this is the job of the judge rapporteur. That is, of course, not to say that this judge rapporteur goes on and does everything alone. And here in the Central Division in Munich, we, of course, have a great team, including a very experienced presiding judge and colleagues that are always open to discuss. So it's really teamwork. Well, that's the work in the Central Division. But besides that, all judges, legally qualified judges of the UPC, are also part of a pool of judges, as we call it. And from that pool, the judges are assigned to various local divisions as a third judge in the local division, where they also are assigned to, besides the local judges in that division. And for me personally, that has brought me to proceedings in various local divisions. Düsseldorf, where we dealt with an ex parte PI request. The Munich local division, where we did 2 PI cases, and one in Vienna. And I can only say I was very fortunate to get to work on these very first cases with such nice and excellent colleagues in the first few months. And maybe as a last remark, what also helps is that I'm a full-time UPC judge. I don't have any national obligations or presidium work, so I can dedicate my work fully to the UPC casework.
Yes, and you have a background as a practitioner, and now you're a judge. So how did that help you?
I think indeed I practiced European patent law for a long time before becoming a judge, and if anything, I guess my experience helps me to have a feeling and understanding for where parties are coming from, and that work has always been international, multidisciplinary teamwork. So in that sense, I guess it's actually a lot like my current role.
The UPC is quite ambitious when it comes to having speedy proceedings at the moment, and also in the rules. How are you dealing with this in your practice?
Yeah, indeed. I mean, I think it's quite unusual actually for a court to have in its rules, as you refer to already, an actual time sort of goal. Which we do. In our rules of proceedings, it says that in principle, a case has to go to trial, which is trial in UPC is typically a 1-day oral hearing in a year, and a decision to follow 6 weeks later. And assuming that we indeed are able to deliver on that, I think you could say that's pretty quick. As to how we do that, first of all, the parties have to do a lot because the proceedings are front-loaded. That is clear from the rules of proceedings, which means that pretty much all facts and arguments have to be presented in the beginning of the case. And the rules of procedure, furthermore, contain fixed deadlines for written submission. And looking at the first orders that have come out in relation to requests for time extension, the judges of the UPC take these deadlines in the rules of procedure very seriously. In the remainder of the proceedings, and in particular in the interim phase, the judge rapporteur, already referred to, is responsible for active case management. So he or she may hold an interim conference and make all sorts of orders to make sure that indeed the case is ready for this oral hearing in 1 year. And then, in addition to that, cases may even be accelerated. Deadlines may be shortened, and it all depends on the circumstances of the case. And that might be also for us under special circumstances in the Central Division the case. Well, having said that, so yes, we want to be quick, but of course, we do not want to be quick at all costs, especially the requirements of due process. That is a fundamental right in the European Union. And we also want to give high quality decisions. So I would say, yes, we want to be quick, but if necessary, we will take longer to meet those very important points.
In your panels, you are also working with technically qualified judges. What have been your first experiences with working with technically qualified judges?
Yeah, so thank you also for that question, Rolf. I can only say my first experiences with technically qualified judges, or as we also call them, TQJs, in the UPC have only been positive, and I know that I am not alone in this assessment. I think it is all colleagues I speak to are unanimously positive. The reason for that, I think, the UPC was, of course, designed to be a multinational court, so there are always judges from different national backgrounds, but also a multidisciplinary court, where you have judges having a technical background and technical experience, TQJs, and judges having a legal background, the LQJs, legally qualified judges. And don't make the mistake that these technically qualified judges are part of a panel as some sort of technical expert, because they are not. They are judges, and they work and decide on the entire case, including legal aspects of the case. But the opposite, of course, is also true. Legally qualified judges don't see themselves and shouldn't see themselves as just judges who are there for dealing with legal aspects. They themselves also develop a deep understanding of the technology and all of the aspects of the case. In my view, it is really this exchange of views and the exchange of thoughts from these different multidisciplinary, multinational perspectives, which really adds value and makes the UPC so unique. Well, here in the Central Division, we are lucky enough to, by definition, on our panel, have a technically qualified judge. So the TQJ is always there with us, 2 legally qualified judges and 1 technically qualified judge. In the local division, technically qualified judges are added to the panel if there is a counterclaim for invalidity, or if the court or a party requests the allocation. And what we've seen in practice is that in most cases, technically qualified judges have been appointed.
That was a very interesting thought about the exchange between the legally qualified judges and the technically qualified judges, because you, for example, have a technical background as well. And also other judges at the UPC have technical backgrounds, although they are legally qualified judges, such as Sabine Klepsch. Do you have any thoughts? I mean, this is interesting. I mean, you say you also, as legally qualified judges, think about technical problems, and the technical judges think about legal problems. So you are really a team thinking about the whole case, right?
No, that is exactly what it is, Rolf. Absolutely, and I think having a technical background maybe helps to be a little bit closer to the technical view, but it is definitely not necessary, and it is indeed the teamwork what it's all about.
Right. I have a more difficult question now for you. So the concepts developed by the EPO boards of appeal, such as the problem solution approach, will they be strictly be followed by the Unified Patent Court, or will national developments, such as determining the inventive step according to the Federal Court of Justice in Germany, be followed, or other concepts such as the concept of the idea of the invention lying behind the words of the claim from the District Court of The Hague, and that sometimes gives a broader protection for the claims than the literal wording. What are your thoughts on this?
Well, I mean, you raise a number of very, very interesting points, of course, Rolf, and as you also already mentioned, for me at this point in time, it's really difficult to give you an answer on this one, especially since all of these issues will have to be decided by panels of the UPC, including panels where I will be a part of, and I don't want to say jump ahead of that right here and now. But what I can say in general is that the UPC, of course, is not bound by decisions from other national courts, except for the European Court of Justice, of course, but that goes without saying, or the EPO. However, like many national courts have been doing for years and are still doing, we will, of course, pay due attention and take note with interest decisions coming from other European courts and decisions coming from the Courts of Appeal of the European Patent Office. And in addition to that, we are applying the same substantive law. It's the European Patent Convention. And in the European Patent Convention, there is the law on patentability and on scope of protection. And that is also our law. And if you look at the past, I don't know how many years in European patent litigation, many concepts have been harmonized by the various national courts. And where there has been such harmonization, I personally wouldn't expect the UPC to go a drastic, complete, different route of its own. But that said, every case has to be decided on its merits. And in the UPC, of course, we are dealing with civil proceedings. And that means that as a court, we are bound, if you will, to the requests from the parties and what they bring to the table. And that will be then the basis of our decision. So I'm sorry, not a very concrete answer here, but well, hopefully still.
Yes, I think it is a helpful answer because that gives the practitioners the hint to bring everything to the table, also national law, maybe in countries where they are not residing.
Sure.
That could be helpful for their clients. So, yeah. So that was a very interesting thought also, although you could not be, of course, making a judgment now about what law to apply. So let's see how this develops. So most cases are currently filed with the German local divisions in German language. Is that a trend that will manifest itself? What do you think?
Another interesting one there. I think, first of all, we will keep seeing cases coming in the German local divisions, of course, clear. But also in other local divisions as we go forward with the UPC. Germany traditionally has been an important jurisdiction, important venue for patent disputes, and that we see that reflected in the high numbers of cases that have always been filed in Germany and are now filed in the local UPC divisions in Germany. Maybe in addition to that, in the German local divisions, because Germany is a so-called big jurisdiction, there are always two German local judges, and that may, with the users at least, give a feeling, sort of feeling, knowing what you get, feeling. Maybe that sort of helps these divisions. But that said, we are seeing cases in other jurisdictions and have seen from these other divisions, local divisions, just to name a few, Milan, Vienna, Paris, Nordic Baltic, Helsinki. We've seen cases all in those jurisdictions and have seen quite significant, important decisions also from the local divisions in those local divisions coming out of the UPC. So that is a note. And if you look at the language used, first of all, the use of German, I've been told by my German colleagues that this use of German in this first half year might also have been caused by the fact that the German government only at the last moment decided to allow English as an official language in the German local divisions. So users didn't know that just before it started. So many cases might have been prepared already in German. And of course, where there are two German parties are involved in litigating each other, I can understand that then German is the language you choose. However, in international disputes with international parties, to me, at least, English seems a natural choice of language. And for the UPC, that will have the advantage that all of our judges are selected to have at least a good command of English. And that also means that no matter what, litigants can then be sure that there are no translations needed of their submissions. There will be no need for interpreters at the hearing, and that might be helpful. And in addition, we've seen changes of language actually being ordered by the president of the first court of first instance in a case, and also sometimes the language has been changed upon agreement between the parties. So that may also steer the language. Again, back to us in the central division, our language is determined by the language of the patent. And as most patents are granted in English, that means that most of our cases are actually in English. Maybe just to go back to this choice of local division, of course, the beauty of the UPC is that we are one court. We have a uniform rule book. That is our rules of procedure. So in the end, it does not, and it should not really matter where you are. And I think this will only get stronger as the Court of Appeal will render decisions which will ensure a uniform interpretation and application of our law. And apart from that, the technically qualified judges, legally qualified judges, we already mentioned the pool of judges and the traveling around. So also these judges being, if you will, flown into local divisions will sort of harmonize the approach. So frankly speaking, I don't see a good reason not to file cases at any division of the UPC.
Right, of course. Another trend I see is that currently, or not trend, but maybe a trend that goes away, we talk about this now, that currently most cases are still filed with the national patent courts for various reasons, so not with the UPC. What do you think are the main reasons from your perspective, and what do you think will the numbers develop over the next years? What do you think?
It's again an interesting but difficult question, Rolf. First of all, I don't really know the numbers as they are. I'd say I'm just a judge, so I deal with the case. But clearly, we're still now with the UPC in first of all in the transitional regime. First 7 years of the court's operation, which means that the disputes relating to European patents can still be brought to national courts. So they are. Especially if a patent has been opted out of the jurisdiction of the Unified Patent Court, then that patent may only be litigated in national courts. And the same obviously goes for national patents, utility models. Those will also remain in national courts, and those will remain there also after the expiry of the transitional period. So clearly, we're seeing actions also in national courts, and that will remain. This opt-out, by the way, is not without risks. In a recent decision we've seen coming out of the Helsinki local division, an opted-out patent where a national action was pending could not be opted in, actually the opt-out withdrawn, again, because the action was pending nationally, even though that action had been started before the UPC's operation. So a word of caution maybe, but the Helsinki decision may be appealed, of course. So that's on transitional regime and opt-out. Of course, the UPC is also a new court. So I can imagine that some users might have been waiting to see what the first experiences with the court are and have been, and what decisions of that court look like. And hopefully in the first orders and decisions we've been delivering so that the trust of the users in the system is confirmed. On this court being new, okay, that the court is new. The judges of the court, of course, many of them are familiar faces, and all of them have been selected for their extensive experience in European patent law. So it is not like at the UPC we are constantly reinventing the wheel. Maybe one aspect that is interesting to mention in this context is unitary patents, because unitary patents are exclusively litigated at the UPC. And what I understand, but as I said, I'm not necessarily a numbers guy, but I understand that the number of unitary patents being granted is really rising. More than 15,000 unitary patents have already been registered, which is about 1/6 of the patents granted by the EPO this year, if my numbers are correct. And all of those will have to be, if they end up in litigation, which of course will be a small percentage, but still, all of those will be litigated at the UPC. What that then in the end means for the numbers over the next years, I can't tell you. But what I can tell you is that as the judges of the court will, of course, do our best and everything we can to deliver high quality decisions in a reasonable time frame.
Right. Of course. Do you have feedback for the users, such as the patent practitioners of the UPC after the first months of operation?
Well, in terms of feedback, Rolf, I really don't think I should be the one giving feedback to the users. But let me just say that from my end, what I am experiencing is a very good cooperation with the parties, and especially where it comes to dealing with the electronic case management system, the CMS of the court. Everybody knows that system is a challenge and is still very much work in progress, but I have seen a lot of flexibility from the parties. I hope that has been experienced also the other way around a little bit, and I'm actually very pleased to see where we've gotten in this first half year.
So thank you very much for your time. It was a really very interesting interview and probably also very valuable for the listeners using the UPC in the future. Thank you very much.
Thank you very much for having me here, Rolf, and it's been a great pleasure.
Thank you.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.